Welcome to everyone who is here. Welcome to Elizabeth Sepper and Stephanie Barclay. Thank you both for joining us. Here, I am Stephen Collis. I'm the faculty director of the Bech-Loughlin First Amendment Center at the University of Texas School of Law. And I am just super excited to have both Professors Sepper and Barclay here. They're two very distinguished scholars in the area of religious liberty, among other things. And thanks to both of you for coming and having this conversation. I think it's going to be really exciting.
Thanks, Steve. Great to be here.
Thank you.
What I'd like to do is I'm going to go ahead and introduce both of you and get your bios on the table so everyone kind of knows just how distinguished you are. And then I'll just say a little bit about format and Q&A and whatnot, and then we'll just jump right into it. Does that sound okay to both of you? Much of this, as it is a disservice to both of you, I did have to truncate your bios a little bit, so I apologize for that, but in the interest of time. So first, Professor Elizabeth Sepper is a professor here at the University of Texas School of Law. She's a nationally recognized scholar of religious liberty, health law, and equality. Her articles appear in top journals, including the Yale Law Journal, Columbia Law Review, Virginia Law Review, Northwestern University Law Review, and Harvard Journal of Gender and Law. She's also the editor of the book Law, Religion, and Health in the United States from Cambridge University Press. Liz is a graduate of NYU School of Law, and after law school clerked for Judge Marjorie Rendell of the U.S. Court of Appeals for the Third Circuit. And prior to joining the faculty here at Texas, she was a professor at Washington University School of Law. During the 2018-19 year, she held the LAPA Crane Fellowship in Law and Public Affairs program at Princeton University. So Liz, so grateful you're doing this conversation and just thrilled you're here. Professor Stephanie Barclay is a professor at Notre Dame Law School. Her research focuses on the role our different democratic institutions play in protecting minority rights, particularly at the intersections of free speech and religious exercise. Her academic writing has been published or is forthcoming in publications such as the Harvard Law Review, the Washington University Law Review, the Notre Dame Law Review, and the Boston College Law Review, among others. She is the faculty director of Notre Dame's Religious Liberty Initiative, is a faculty affiliate of the Constitutional Law Center at Stanford Law School, and is the chair of the AALS's Law and Religion section. She is a graduate of BYU Law School, and after graduation clerked for Judge N. Randy Smith on the U.S. Court of Appeals for the Ninth Circuit. And starting this next term, she will be clerking for Justice Neil Gorsuch on the United States Supreme Court. So Stephanie, we're grateful we got you before you jump off to your clerkship. Thanks for being here. As far as format, we're going to go ahead and Professor Sepper will jump in first and kind of introduce her paper or her article that has been quite influential in this field now for a number of years. And then hopefully we'll have a nice robust discussion about that. I would encourage all participants, if you've got questions, just throw them into the Q&A, and I will do my best to kind of collate those and bring them up as we can to keep the conversation going. I don't think there'll be any shortage of things to talk about, but we really do encourage everyone participating to get their questions out there, and we'll do our best to address them. The only thing I would say to both of you is I know for a fact that not everybody in our audience are law students or law professors. We do have some lay people. So do your best if you can to define some terms. For example, Professor Sepper, I don't know that everybody knows what Loughnerism means right out of the gate. So I know that's hard, a big ask to do, but to the extent we can try to help people understand some of this, all the better. So with that, Professor Sepper, let me turn it over to you, and you can introduce us to your paper, Free Exercise Loughnerism.
Thank you for having us. I'm really looking forward to chatting. So free exercise Loughnerism is a descriptive label that I use for the approach that courts have taken to religious exemptions for businesses, both nonprofit and for-profit, but arising primarily in the for-profit space. Now, when I say free exercise Loughnerism, what I refer to is an earlier series of cases, the Loughner case, a 1905 Supreme Court case that is symbolic of a tendency of the court 100 years ago to strike down economic regulation of businesses based on dual premises. And those two premises are an ideal of private ordering and a resistance to redistribution. Okay, so I use the term not to be provocative because it is a provocative term in the legal academy, but rather because the comparison to Lochner usefully surfaces two themes, I think. First, it shows that the underlying premises of this flavor of litigation don't sound in the religious liberty tradition, but rather in market libertarianism. And second, the similarities to Lochner reveal that corporate religion doesn't merely affect women and gays, as is so often assumed, but instead has the potential to carve out exemptions for a wide swath of economic regulation. So I'm going to walk through very briefly, I've been instructed, the construction of religious liberty cases in Lochner's terms. Now, I want to make clear, this is not a comprehensive theory of doctrine. Many religious exemption claims don't advance economic libertarianism. Okay, so first, private ordering becomes the baseline for religious exemption. So the legal claim is often explicitly in courts and by litigants described as a right to run one's business as one sees fit. So as in Lochner, we see a melding of rights protection and contractual freedom, and it's most evident in the employment relationship. So many objectors, for instance, to the contraceptive mandate, express their religious claims as a right to contract with their employees. And then the market becomes the relevant baseline against which to measure the constitutionality of regulation, of the burdens that regulation might put on a religious objector. So second, regulation is thought to unfairly disrupt this private ordering between employer and employee, or business and consumer, or landlord and tenant. Any change then from the market as defined by common law rules of contract, property, and torts prompts skepticism as a form of redistribution, precisely as it did in the Lochner era Supreme Court. So under free exercise Lochnerism, regulation that's seen to redistribute imposes a substantial burden on a business's free exercise of religion by impeding its contractual freedom. So on this account, what individuals are really seeking when they want contraceptive coverage through their employment coverage is a subsidy from their employer. They're demanding entitlements from businesses that are seeking simply to be left alone. Or maybe, if we reframe in Coasian terms, employees are imposing externalities on their employers in the form of adequate preventive services coverage. In its brief to the Supreme Court, Hobby Lobby again put this expressly, saying the ultimate question is who will pay for a third party's contraceptives. So on this view, the contraceptive mandate granted employees more than the fair value of their labor. The notion is that private negotiation should set compensation and employees should be held to the terms of their bargain. In turn, this approach shrinks the government's interest in regulation to ensuring market access. As long as there's a competitive market for employment or wedding services or housing, regulation does not further a compelling interest. Anti-discrimination laws goals, for example, are reducible to access to market goods, not ensuring equal status, opportunity, or dignity. And on this view, the private order then operates as a least restrictive means to further any governmental interest in market access. The market will provide, just let the market work to ultimately get a person a wedding cake or contraceptives. As in the Lochner era, the responsibility for any inequality in the market is to be borne not by businesses, but by individuals and by the public. If not the market, then the government must provide. Let the public pay. Well, so what's the problem with this approach? Well, it's blinkered to subsidies that exist. In the contraceptive mandate context, employers benefit from massive subsidies, and yet this court seemed blinded to that. They assumed a neutral and naturalized market baseline against which to examine religious exemption claims. It also ignores that the state and the law are everywhere. Property and contract rules are the government, that there is no neutral and natural market functioning. It also denies the massive power imbalances that exist in the world, especially as between employers and employees. Now I'm probably already 1 minute over time, but I'm going to say, right, this paper came out in 2015. I think there's been some moves that don't look like what I described here. I think, and we could talk maybe about the most favored nation approach that the court seems to be taking in the COVID cases that I sort of nod to in the paper. But in some ways, this court is now more Lochner than the Lochner court, more Lochner in a move away from enforcement of government contracts, which I suspect we'll see in Fulton, which I suspect we'll also talk about. And also in devaluing the compelling interest governments have in public health. I have no doubt that in 1905, the Supreme Court would have taken much more seriously the threat of a pandemic than the current court of 2021 seems to be taking it. So I will leave it there. I think I'm 1 minute over time.
Well, absolute kudos to you for staying within time. That's like an impossibility for most law professors. So you get a special award for that.
It was
Stephanie,
tough.
I know. Stephanie, what are your thoughts? I mean, I can send questions your way that I have, but I'd love to just get your overall reaction and let the two of you really have a nice, robust dialogue about all this.
Yeah, no, it's all really interesting what Liz was talking about. And I am interested in more of your thoughts on subsequent developments past when this article was published, Liz. I guess one initial question that I had as I was reading this is, so I think you do a good job tracing some of what was going on in the Lochner era and why many scholars view that as problematic. But in one of the primary cases that repudiated Lochner, that was Caroline Products, where there the court was upholding economic legislation, but was also making clear that while now the sort of the general rule was going to be rational basis for things like economic regulation, we of course have the court's famous footnote 4, where Justice Harlan Fiske Stone, writing for the court, is indicating that there are still going to be some important areas where we do still have strict scrutiny, or they didn't use the term strict scrutiny at the point, but skepticism of what the government is doing, a presumption of private ordering, and a harder look at whether or not the government has a justification for the type of regulations that it's putting forward. And of course, one of the areas where Caroline Products indicates that will continue to be true has to do with not just Bill of Rights, but religious minorities as well. And so specifically calling out these sorts of religious rights. So why isn't this consistent still with these cases that repudiated Lochner generally, but still indicated a need for more rigorous scrutiny where we have some of these sorts of individual rights at stake? Why isn't this just Caroline Products-ism of the free exercise clause taken in a more robust way? What has been happening with the court? I'm interested in your thoughts about that.
Yeah, I don't think it's inconsistent, right? The problem with the Lochner era was not scrutiny per se, right? Maybe it was at the level of economic regulation, but it was how the scrutiny was being done, right? I think there's plenty of constitutional basis for a right to contract, but it was how it was done. So I think that there's nothing in Caroline that would suggest an idealized system of private ordering. There's certainly nothing that would suggest a resistance to redistribution. So I think that judicial review can be done in ways that think more about equality, for instance, right? Another theme of this talk, think about the constitutional system that we want to live in and different values at play without idealizing a purportedly natural or neutral market, right? Looking underneath the hood to see where subsidies lie. I also think Caroline Products, with its focus so much on discrete and insular minorities, never would have thought that that multi-billion-dollar corporations were within the realm. I also think, right, when you're talking about Caroline Products, you're talking about a historical point at which corporate constitutional rights in the form that they have grown into today didn't exist, right? They were property rights, they weren't liberty rights. That's a significant change that I think changes the valence too of Caroline Products.
So just to follow up on that really quick is, I guess, two questions. I'm interested in what you think heightened scrutiny would look like or should look like, in a way that takes into account some of those equality interests you're thinking of, like, because generally when a court is approaching some sort of government action, there's of course a whole range of the tiers of scrutiny, but if we're painting in broad brushstrokes, the court has the option of either giving some version of a presumption of constitutionality or some version of a presumption of unconstitutionality. And those are two primary buckets in which courts will approach what government has done. And so what does that look like for you? What do you like, which way does that cut? Do you think that should cut if we're dealing with a case that involves religious rights, but some of those other interests? If we're just trying to give guidance to courts to how to do that sort of scrutiny better, maybe I'll pause with that question, but I do have a second question as well. And Steve, feel free to interrupt me at any time.
I mean, I think that, sorry. Yeah, so these are really hard and big picture questions. I mean, I think what the court was doing in the Sherbert time period before Smith was, I think, clearly, or at least what lower courts were doing maybe as well, was not pure, it wasn't the kind of fatal in fact strict scrutiny that we see in some other areas, right? But that's, the Constitution isn't monolithic. Different constitutional claims result in liability or don't. Courts invent doctrines that mean that some constitutional rights are weak sauce and others are supercharged, right? So you can think of qualified immunity as one of the doctrines essentially invented to avoid supercharging certain rights. Free speech has been supercharged. Free exercise was somewhere in between, but I think it's being supercharged. I mean, I think, right, thinking about governmental interests in a robust way, right, thinking about what matters and to whom, and to think about hierarchy relations and systems of power is a good way for courts to approach issues of religious exemption. Exempting someone from a dress code in a school is quite different from exempting someone from wage and hour laws who has thousands of employees, right? There's different valence there, different weight in the government's interests. And, other people will face repercussions, whether or not you want to call them third-party harms, of exempting individuals. Or you can just adopt the hard line and go Smith and say that we shouldn't be doing strict scrutiny here at all. I don't think we need to go that far, but there are people, that we both know that certainly would.
So Stephanie, can I ask a follow-up question? Do you mind?
Of course, yeah, jump in.
So Liz, I'm just curious then for, I guess, what level of scrutiny or what approach to scrutiny do you think makes sense then to allow courts to be able to address all those very interests you talk about? I mean, maybe this is just a variation of Stephanie's question, but I'm curious, the way you were talking, it almost sounds to me that, well, the compelling interest test can do its job. You're just saying courts should be considering all of these other factors when it does the compelling interest test. But I'm curious if you would agree with that approach, or if you think some little, intermediate scrutiny might make sense, a la Jim Oleski's article in the Wisconsin Law Review. That, I'm just curious where you come down on that.
I think that courts were doing something that doesn't look like what we think strict scrutiny is, right? Which is to say fatal in fact. If you look pre-Smith, right, there was the decisions tended to disfavor religious objectors as much as if they favored them, right? It wasn't a system in which the religious objector could be expected always to win. And so I think something like that intermediate way makes sense for a number of reasons. One, because of this corporate constitutional rights, right? I think those present distinct dangers that are quite different from allowing individual people to claim religion. All the Smith-related reasons, right? In order to raise a free speech claim or a Third Amendment claim, right, you need very distinct facts, right? Not every single piece of law will tell people anything about how they have to speak or tell corporations about speech. But every single law could implicate religion, right? There's no bounds to religious objection. So I think that does matter. But I think anything that idealizes the market is going to disfavor regulation, right? If you naturalize the market and say, this is not state intervention, the government isn't acting, no one is harmed by the market, then we end up in a universe that distinctly favors exemptions from economic regulation as opposed to the sorts of regulation that we saw challenged in the past, which could be described in large part as about people wanting to join our community, right, with their religious beliefs intact, as opposed to forming separate religious communities. Not always true, but I think more accurately.
Yeah, I mean, I think that you're right, Liz, that strict scrutiny in the 60s and the 70s it had some differences to it than how courts are applying it under RFRA today. I think that's also true in the speech realm. Strict scrutiny has become more robust in some speech areas because, in part, strict scrutiny didn't exist until a formal doctrine until the 1960s. So that test has been evolving, and I think you're right to note that. So I guess one thought that I want to throw out there, and feel free to react to this however you want, Liz, but I think that you do important work drawing attention to the way in which courts are looking at market access as a less restrictive alternative, and you raised some important questions about that. So if we focus in on the contraceptive mandate arena, there where the Supreme Court famously, at least in Hobby Lobby, talked about the fact that government could provide some of these programs directly if that was important to it. What I take the court to be doing there, at least in part, isn't necessarily saying that that's the idealized vision of ways in which these goods or services should provide, but in part sort of trying to nail the government down on what its interest is. And so if the government's interest is just to make sure that women have access to contraception, then there are more ways to get that done. There's more ways to skin that cat than just having it provided through the plans of these objecting religious organizations. On the other hand, if the government's interest is the seamless coverage through the same plan as it has been using before, then that raises some other problems for the government. One of which that the government didn't come up with that rationale until midway through its litigation process, and sometime in front of a DC Circuit Court, I believe, and that the government has a lot of lack of even-handedness in the way in which it's requiring employers to offer seamless coverage, and the amount of employers, the US military, for example, who are exempted from doing that sort of a thing. And so what I take the court to be doing with that analysis is just trying to line up the means and the ends and say, okay, if government, really what you're worried about is access for women, then what about all these other ways to get that access? And if government, your interest is really seamlessness, then you have more work to do to both prove that you really treat that as a compelling interest and that you're being even-handed about that.
Yeah.
Liz, before you answer, let me just say, after you answer this, we've got some great questions from Andrew Koppelman I'll throw out to both of you. So go ahead, Liz, but I wanted to flag that before we move on to another topic. Go ahead.
Hi, Andy. Oh, I can't wait to hear. Well, okay, so now I'm putting on my health law hat to say that the Hobby Lobby court lives in a la fantasy land where healthcare doesn't work anything like it works in the United States, right? So 2/3 of people get their coverage through employment, which means that the best way to handle the problem of big gaps in coverage for contraception, especially no-cost contraception, which was basically unheard of before the ACA, is to require employers to cover contraceptives. And it's made a huge advance. Like, we see this in real time affecting how women and families are able to make choices about both contraceptive method and family planning generally. Also, the government does pay for employer-sponsored insurance. It's our third biggest health expenditure, narrowly behind Medicare and Medicaid. So it's just a universe where the government is basically paying Hobby Lobby to provide employer-sponsored coverage. So it should have something to say about how this works. The notion that Title X family planning could cover contraception for people is truly fantastic, right? The funding for Title X is about 40% of what it needs to be to cover current needs, and they're needs for poor people, not for middle-class people who get employment sponsored insurance. So I think there's just a total disconnect from reality. I guess it also presumes a unitary government. We know that's not how this works, right? There was a once in a generation kind of option with the Affordable Care Act, right? To make major moves in healthcare. It wasn't going to solve all our problems, and it doesn't. But I think that it's quite detached from reality to reason, as the Hobby Lobby court did there. What does Andy have to say to us?
Yeah, so Andy Koppelman from Northwestern, welcome. Thanks for these questions. He also has an interesting article in The Hill in the past couple of days that might be worth taking a look at for those who are watching. So he points out that we're not really talking about direct discrimination as we saw maybe in Lukumi, targeted discrimination. We're talking about instances where there are inadvertent burdens on religion. And he asks the question for you first, Stephanie. He says, wouldn't it make more sense just to ask whether the government interest would be defeated by the exemption, rather than using terms like illegitimate scrutiny or strict scrutiny, or having a presumption that the government interest is illegitimate? And then for Liz, he asks, wouldn't such an approach avoid naturalizing the market?
So I agree with Andy that I think the most important question at the end of the day is, if we offer this exemption, is it going to defeat the government's interests? I guess I would caveat that I don't think every government interest counts. Like, I think that one thing that the United States is doing well that other countries don't always do as well is we do filter out some of the things that the government is motivated by. And so in France, the government there, the court found was justified in its policies that essentially resulted in a burqa ban for Muslim women. And the government's interest there was getting along together in a secular society. So if the government can point to any interest, then it can always find a way to justify infringements on religious exercise in ways that sometimes can really have disproportionate impacts on religious minorities and unpopular religious beliefs. But assuming that we have some heft behind whatever the government's interest is, then I agree. The ultimate question is just, does providing this exemption defeat the government's interest? Which is what I think, and this goes back to what I was talking about with Liz earlier under contraception, that's what the court was ultimately trying to ask in some of the contraceptive mandate cases. First, what is the government's actual interest? Is it just access, or is it more specific than that? And if so, does this really defeat that interest? I mean, Liz is right that most people receive healthcare through employer plans, but one thing that the government acknowledged as part of that litigation is that one of the reasons that the government hasn't required its own, military to provide seamless contraception is because a lot of those people are able to get access on a different employer plan of, say, a spouse or something like that. And so I think really what the court was pointing to was some of the inconsistent reasoning of the government in terms of how it was trying to enforce these interests as opposed to idealizing the market. But to your other point, Andy, about does this not fit very well in Caroline Products footnote 4? I mean, that footnote 4 does talk about reversing that presumption of constitutionality, not just for discrimination, like a la Lukumi, but also potentially for legislation that appears to be within the specific prohibition of the Constitution, such as the first 10 amendments. I happen to think that the Free Exercise Clause is concerned about inadvertent burdens on religious exercise as well. That's something else that I've written about. So I think it's maybe a better fit than some of our current constitutional doctrine suggests, but to a broader point Liz was making in her paper, RFRA sort of is operating in a quasi-constitutional way to restore that standard. And so we're also thinking about it in those terms as well. Liz, feel free to jump in on that or to answer the other excellent question Andy asked. And thanks for jumping in, Andy.
Yeah, I mean, I'm gonna follow up on Stephanie and then answer the more targeted question that Andy directed toward me. Yeah, I mean, I tend to agree with you, Stephanie, that I mean, to my mind, stretching, Lukumi involved really serious animus, targeting, discrimination, and we've just seen it stretched beyond any comprehension to my mind, right? Like it's so that any tiny indiscrepancy in treatment becomes discrimination a la Lukumi, that kind of targeting. I think that's just bad analysis, and it's the kind of thing where in the common law we would see courts just move away from it. So you've stretched this concept until it's meaningless. Let's do something else and say what we're actually doing. So if we're actually doing inadvertent, as Stephanie put it, burdens, right, or unintentional burdens, then let's say that and develop an actual regime that applies to that kind of burden, not to intentional targeting of religious actors. As to Andy's question, whether by asking, is the government interest defeated by exemption? Can't we avoid naturalizing the market? Sure, in cases where courts aren't inclined to naturalize the market, but not necessarily in cases where they are. So just to give an example, if we think about the public accommodations context, where same-sex couples are seeking to receive the same goods and services as everyone else, to be treated equally, to be able to go into any business, just as claims around public accommodation have always been about equal access across the marketplace, right? That's a way to think about the government interest. That's the accurate way to think about the government interest. But if the government interest is instead defined, as litigants define it, and the courts are starting to accept, as simply getting a wedding cake, right? That does give the market primacy. It naturalizes a way of functioning. And so it says the government interest is served. It is not defeated by exemption as long as you eventually get a wedding cake somewhere in the marketplace. It simply says the market, this natural, beautiful, neutral market, gets you to the same place as government intervention does, and everyone does better. So I think that does, in fact, naturalize a market and treat it as neutral as to harms.
So Liz, we have you might see the question here from Jim Oleski, and I'm going to throw this to you. He says it's for either of you, but since Liz, this will be your chance to wrap up your time, and then we're going to pivot over to Stephanie's paper and let her introduce hers. So Jim asked the question, though, if you think the Tandon approach, so the Supreme Court's just recent opinion for our audience who may not be aware in the last couple of weeks as part of their shadow docket, if that approach there might get extended to free speech claims, and if secular speech activities like religious activities get most favored nation treatment, does that raise the Loughnerization concern for you as well?
Jim should know that I don't touch speech. I'm afraid of the rest of the First Amendment. Okay, so I think there's a serious Establishment Clause concern now with the sort of Tandon approach with the most favored nation, whereby religious actors get exemptions, but the same regulations continue to apply to like secular gatherings, right? And you can think of other examples as well. There are religious schools who objected to certain rules that were being imposed on all schools. They got exemptions, and then other private schools that might have similar interests but are secular don't get that same treatment. That seems constitutionally problematic. Does it raise the Loughnerization concern? Well, I don't know. It's not clear to me on the 3 household rule and exactly the valence of Loughnerization concerns when we're talking about religion or secular activities. So frankly, I would have to think about it more. As I said, not all religious liberty claims raise concerns about Lochner. It's same is true, I think, of free speech, though again, I don't like to touch free speech. Not as brave as you, Stephanie.
Steve, can I ask Liz one more question? Because I think her paper is more fun to talk about than mine.
Hey, if you want to do that, sounds good to me. Go ahead.
And thanks, Jim, for jumping in. Good to hear from you. Liz, I guess one quick question I had, because you spent some time talking about the power dynamics and the valence of now corporations are asserting rights and how that affects the analysis. I'm curious how that cuts for you in a case where a corporation is claiming a First Amendment right to promote contraception and to challenge government regulation that is trying to restrict or curtail that. One such case is Bulgar versus Young Drugs Products, where a corporation was bringing that type of First Amendment claim, arguing that it should be able to promote more contraception. So I'm curious for you, is that still an example of, this Lochnerism in a corporate way because we're challenging those regulations, or is it different based on how things are cutting with the contraception in that case?
So it's a religion case.
It's a speech case.
Yeah, of course it is. So I think right, you can find ideal of market, right? It's not necessarily about the political partisanship that determines whether something is Lochner or not, right? Some people would use it in that way, but I really want to stay focused on the ideal of the marketplace and the resistance to redistribution as being two central animating premises. Not sure how redistribution would play exactly in the example, partly because I'm not as familiar with it, but it does seem like an ideal of market mechanisms and market neutrality might be at play there, where I would think it was very much in line with that sort of Lochner argument. Yeah.
Okay, makes sense. That's helpful.
All right. Well, with that, Stephanie, why don't we pivot and let's have you give us a 5-minute introduction. We'll see if you can do as well as Liz did in limiting yourself so that we can actually have a conversation, but I understand if it's difficult. But go ahead, introduce us to your economic approach to religious exemptions article.
Yeah, Liz is a tough act to follow. She has set a high bar. So, all right. The article that I'm talking about is an economic approach to religious exemptions. And it's engaging with an idea that we often hear in the media or scholars engaging in it. It's the idea that religious rights should be protected only to the extent that they don't result in harm to others. My right to swing my fist ends where it hits your nose. That's, the received conventional wisdom in many circles. And iterations of this argument have become increasingly common, not just in the academy, but amongst some judges. Justice Ginsburg famously, and even in the halls of Congress with bills like the Do No Harm Act and the Equality Act, which are legislatively proposing ways in which religious rights should be limited when they result in harms to others. And Liz sort of mentioned the idea of third-party harms earlier in her discussion, so I'm looking forward to chatting about this a little bit more. This argument has taken on particular salience in light of the pending Fulton case before the Supreme Court, and also I think has developed a lot of urgency with a lot of the disputes about harms caused by religion and religious gatherings in this era of COVID and the pandemic that has swept the globe. So what some scholars, my friend Professor Fred Geddix and Rebecca Van Tassel, famously described as the idea that harms flowing from religious exemptions, these are what economists call a negative externality, because they shift the cost of accommodating religion from those who practice it and benefit from it. They shift that cost onto other people who are not benefiting from it. That's what an externality is, when someone is paying for something for which they do not benefit. And similarly, Professors Doug Najim and Reba Siegel have argued that laws should restrict religious accommodation when it's harming others. And Professor Micah Schwartzman and Nelson Tebe and Rick Schrager have some really eloquent arguments along the same line. They argue that forcing third parties to pay for the exercise of other constitutional rights is disturbing, and that our Establishment Clause basically prohibits that. And Liz, I know you've made arguments in this vein as well. So one thing that I'm arguing about or talking about in this paper is that these new progressive theories about harm are trading on rhetoric and normative intuitions regarding externalities and costs. But I think, at least so far, these theories have largely ignored an influential theoretical movement that has studied these sorts of externalities and costs for the last 50 years, and that's law and economics. And so if we sort of take that lens and look at this problem, what different insights might we have? One thing that I think is interesting is my friend Fred Geddix has spoken before about how religious externalities are sort of like factories polluting neighboring properties. And just like economically, we would restrict those externalities from a factory, we should do the same for religious people. In a way, this sort of framework is unintentionally partaking of economic theories advanced by Arthur Pigou, who was arguing that government should intervene anytime someone was not internalizing their own costs. And that was prevailing economic view prior to the work of Ronald Coase, who thought really carefully about externalities, and in particular, the nature of reciprocal externalities. Coase forcefully argued that it's theoretically wrong to assert that if A inflicts harm on B, then government must restrain A. That overlooks entirely that there are always reciprocal externalities at play in any conflict. People are always harming each other. They're always imposing externalities on each other. And so that's, I think, one insight that you can take away from some of these debates, if you're thinking about this particular lens, is that to the extent externalities are the relevant criteria for our normative thinking about these sorts of disputes, it is not sufficient to just point to externalities on one side as a justification for government intervention. That overlooks entirely the reciprocal nature of the problem. And another thing that I talk about in this article is just thinking about the economic nature of some of these things. Well, actually, yeah, I'll jump to that. Is that there are a lot of different areas in markets in which there are obstacles to individuals being able to perform in ways that society or others might wish that they would. One is when individuals have idiosyncratic valuation, which means that they value something more highly than others do. And so it would be an activity or a bargain that they are less likely or less willing to participate in. And for religious objectors, this is sometimes true of their religious beliefs. For them, doing something like providing contraception or participating in a war, being conscripted into the military draft, those things are more costly to them because they put a different sort of value on things than others might. And we can talk about this more later, but there's a whole host of literature about how we deal with idiosyncratic valuation, the prevalence of it, and the different sorts of ways in which we often require government to justify when it is going to force someone to do something contrary to their idiosyncratic valuation. And the last thing I talk about is in this article, the importance of thinking of ways that we can decrease net harm across the board. How do we decrease harm on both sides of the ledger? How do we think about problems of reciprocal dignitary harm, which I think is a really sticky wicket, and maybe something we can get into a little bit more in the discussion. But the bottom line is, I think that as a normative matter, if harm is a relevant criteria, that's a more important question to ask, is how do we try and avoid avoidable conflicts? How do we try and decrease harm all around? And as a doctrinal matter, I think that sort of mode of analysis is not that far off from what courts are doing right now through analysis that looks similar to strict scrutiny. I'll go ahead and pause there. I don't think I was quite as concise as Liz was, but I'm looking forward to both of your thoughts, Liz and Steve.
If the baseline is the traditional law professor, you were both incredibly concise. Well done. It's hard for law professors to stop talking. So good job. Not a knock on the profession. They just have a lot to say. So Liz, what are your thoughts? I noticed you said you wanted to maybe jump on Andy's other question as well. So if you'd like to do that, go ahead.
Well, let me just raise a question for Stephanie first that I struggle with, because to some degree it strikes me that everyone writing about third-party harms generally agrees, right, that there can be harms on both sides, right? So it is about getting the right balance, right? But then I wonder what Coase can really add in terms of telling us what counts as a harm, and then maybe just as importantly, what weight to give any particular harm, right? So toward the end of the paper, you say that Fred Geddick's and Andy Koppelman's joint paper isn't really about harm, it's about asserting a moral position. But I had read it as talking about harms, right? Harms to women's health and to future pregnancies from failure to cover contraceptives, right? And then they weigh that harm pretty heavily as against interests that for-profit corporate employers have in withholding that coverage. So I'm wondering if COAST can get us through that, which I really think is the really sticky question. What counts as harm? And then even assuming general agreement on what counts, what weight do we assign the harms?
Yeah, those are all really interesting questions. So to your first point about like people recognize, or there's some discussion of harms on both sides, to some extent, I mean, some of the scholars in this space, I think, acknowledge, yes, there's a harm for a religious person, but still, if what they're ultimately saying is, if we have more than de minimis harm for an identifiable group of third-party individuals, then as a normative matter, that is a sufficient reason that we must always give primacy to those harms, then we're not actually in any meaningful way reciprocal nature of the problem. We've given an essential trump card to one side of harms on the scale. We've simply paid lip service to the harms on the other side of the scale, but not given them any reciprocal weight in whatever criteria we're using for the definition of harm. So I think COAST does help slow down the analysis. This is one thing Michael McConnell was talking with me about, but just really highlighting like how easy it has been for economists prior to COAST to just give primacy to one type of externality, and how that's a flawed sort of reasoning. And I think a flaw that some of this scholarship has partaken in carefully, and really acknowledging the existence of harms on both sides. You're right that still doesn't resolve the issue of how do we weigh them. And my ultimately give like definitive answers to all of those questions, but at the very least, I think whatever weight we choose for a type of harm, we have to apply in an even-handed way on both sides of the ledger. So, for example, with the problem, which is something that I know you have talked about and other scholars have talked about, Liz, I think that this is an area where there's a number of different options. On the one hand, we could say, if we're recognizing the reciprocal nature of the problem, and that third-party individuals who are not benefiting from a religious exemption might have serious dignitary interests at stake if we grant, we can do that. And if we're thinking about the things on the other side of the scale, also recognizing that there are dignitary harms that cut the other way. I'm thinking about, for example, where Sharon L. Fulton, one of the foster mothers, has spoken about, and in her declaration talked about the dignitary harm for her of having her city that she has grown up in say, you can no longer religious agency, and their religious beliefs, which you share, aren't welcome in our city. That's a dignitary harm on the other side of the scale compared to the interests potentially of foster parents who identify as LGBTQ, who feel rejection or lack of the ability to participate in the system without impacting their dignity. And so if we're thinking about those, one option is maybe the dignitary harms cancel each other out. And so we have to look to other sorts of interests. Another option, I mean, some economists say that you have to point to more concrete harms. And so maybe the existence of the dignitary harms is something real and important for us to acknowledge as a painful, difficult thing, but not something that we will actually weigh on the scale. You might have a system in which you say dignitary harm is more troubling if it is being inflicted directly by government as opposed to private individuals. Private individuals inflict dignitary harm on each other all the time. Or you might have a different argument you make where you say one side's dignitary harm just matters more. But at that point, my point when I talked about other moral arguments is that it seems like some other normative theory is really doing the work then. We're no longer just relying on harm. And so if that's true, if we're going to give primacy to one, then I think we just need to be more transparent about what is doing the normative work to justify that change and how we're balancing similar sorts of harms.
So Liz, I don't want to, if you have a response or you want to ask another question, that's great. If not, I would love to, I'm curious if both of you really could talk about downstream harms. This is something you bring up in your paper, Stephanie, that as we're balancing harms on both sides, we really need to consider the downstream harms. It strikes me as I just sitting here that there could be downstream harms in both directions as we're trying to look at harms on either side of some of these disputes. And I don't know if you can elaborate that on a little bit. I think our audience would appreciate understanding it a little bit better.
Yeah, that's a great question, Steve. So downstream externalities or harms are things that are going to affect not just the parties in a dispute, but what's going to happen if they lose this dispute to other people, sort of on a daisy chain of causal events that are affected by this individual and or institution. And so there's two different ways in which this analysis can take place. On the one hand, on the bigger, more abstract level, the absolute true answer to that question is going to be unknowable. Academics can debate about it all day long and have a lot of interesting thoughts about all of the ripple effects of a particular harm in a given setting. And I think those discussions are interesting. But on a more sort of concrete and in litigation, one thing that the process of heightened scrutiny, I think, does well is it requires the litigants to marshal evidence regarding harm to them and also potentially some of these downstream externalities. And so then that question is limited, at least in terms of time and scope and the evidence put before the court. And we have to weigh that and figure out, well, what is going to be the harm to these different parties in this case. And so in Fulton, for example, if we're thinking about the court proceedings there, the Catholic agency in that case did bring in evidence about other downstream harms to other parties, like the 300 foster children that the city had admitted were in group homes and needed to be in foster homes the same month that the city announced that it wasn't going to be working with the city anymore. And the Catholic agency was pointing out, right now, at this very moment, we have 30 beds sitting empty that we could take to us. And these are with awards that the city has given awards to before. So these are some concrete harms we can point to with the downstream effects of the city's policy right now. We can point to the harms to other parents taking children. We can point out a lot of the evidence of what happens to children when they don't find a family, how if they age out of foster care without having found a family, their likelihood of ending up back on the streets, addicted to education, in poverty is very high, and it's disproportionately high for minority children. And then also, even if we were just shifting agencies, shifting kids from one agency to another, there's studies that talk about how even changing a social worker one time dramatically reduces a child's chance of finding permanency. The city pointed to some of those studies as well, but the city in those hearings wasn't able to point to any families who had ever been denied the ability to foster or adopt, or any children who had been unable to find a home because of a religious exemption that had been granted to CSS, or their ability to practice their religious beliefs as they had been doing. So in terms of what was the evidence that we had about downstream externalities in that particular court hearing, there weren't any concrete families or children or homes that the city was pointing to that were resulting in those sorts of harms that later different amicus briefs have pointed to or theorized about being possible, and I think are interesting to think about, but different from what evidence was presented in that sort of limited setting.
So, I mean, I don't think I think that we should use the language of downstream harms, right? I think it's just consequentialism all the way down, right? What are the consequences of this decision? What world do we live in then as a result? I do think that the free exercise exemption doctrine invites consideration of third-party harms, because it asks, right? it asks first, what's the harm to the religious objector? That is just built into the analysis, right? The substantial burden. Is the burden substantial, right? So there's this burden. Assuming it is, if we pick it off the religious objector, where do we put it? If we put a burden onto the state and the state can disperse it really good at law spreading, that seems okay, right? And that's what all these people who are making these arguments, Micah Schwartzman, Rich Traeger, Nelson Tebbe, and the like are arguing. If we pick it up and slam it onto their employees, though, right, that's the third party harm. But I don't think the ultimate consequences then of a decision one way or the other are thought of as third party harms, right? Even downstream, it's just the consequences of a decision. I think we don't know what the consequences will be. But I also think that we are in a time when people are thinking more creatively and less in a status quo preserving way than courts like, right? Frankly, we should be talking about abolishing foster care, right? Catholic Social Services is part of the adoption industrial complex, right? Dorothy Roberts, lots of people within adoption services have talked about these problems. We take brown and Black children from their families for reasons of poverty, not reasons of abuse. And that system should really be rethought. A decision in favor of CSS ends up with greater preservation, I think, of the contemporary system and the industrial complex we built up around it.
I guess I have seen government really good at is a litigator, discrete person that the harm is falling on. So I don't actually think that there is ever a case where the harm just diffusely, sort of nicely, uniformly fades into the ethos of the general public in any sort of even-handed way. This is something Cass Sunstein and Professor Holmes talk about in their book about the cost of rights. Anytime we protect any constitutional right, there are always going to be some parties who in society bear more of those costs heavier than others do. And that's something that Coase talks about as well. There's no way to protect any sort of right or interest without it costing someone else something, and often in unequal ways. So one of the examples that Micah and Nelson point to of the harm that they are saying is sort of the paradigmatic example of falling diffusely on others is if we granted an exemption for a kosher diet for a prison inmate, and that would be okay because it's just a harm that we absorb as society. But it turns out that in actual litigation, government has, in a number of those cases, pointed out ways in which if we grant kosher exemptions and decrease our budget, that is going to result in us having less of these resources for these sorts of specific inmates, things that they would be entitled to. It's going to result in more security threats to these discrete, identifiable prison employees, and ways in which we're making their jobs more difficult. Facilities. I mean, government can always do that. It's not hard. That's straightforward litigation tactics. And so, what we're really saying, if that was the rule, and thankfully, I'm glad it's not actually the doctrine right now of how it works to create that sort of trump card. We're just really saying that all we will do is acknowledge the existence of a religious harm, but then once government is able to point to anybody on which the harm falls disproportionately, which will always be true, then the religious individual will lose. And I think that would be a really troubling rule for a lot of different reasons. Your thoughts about foster care, I think, are really interesting, Liz. Probably part of a broader discussion about. I agree there's lots of problems with foster care in general. I think we'd have to have serious alternatives on the table to take care of Black and brown children who are often being malnourished and abused. I mean, those situations are real. I have talked to some of those children who have come out of those homes and had really heartbreaking experiences. And so I think it'd be an interesting discussion to have about how do we better serve those children? How do we make sure that we're giving them more opportunities that merits more attention? I agree.
So we are at the witching hour, but I would love, now you two can trump me on this. I'm being a horrible moderator here, but if we maybe were to go say 5 minutes over, you could each have maybe your last 2-minute statements, and then we could wrap up, or we can just wrap up right now. Do you have a preference?
No preference. I see we have a question from Kim.
So Kim is responding to a student. Maybe we wrap up with this, okay? There's a student who asks, if they're interested in First Amendment law and religious freedom policy, what resources should they study to get started in the field? Why don't each of you, at least in the name of helping out students, maybe provide some insight into that? Kim's response is actually to the student about that. So Liz, what do you think? How can people get involved in these issues if it's something that they're interested in?
Wow, I guess it depends on where they're a student to some extent, because I think at UT we have a wealth of resources. We of course have your clinic and the center. We have Larry Sager and Doug Laycock and me here working on religious freedom issues. I would suggest, as an initial thought, right, one fun thing to do can be listening to Supreme Court arguments. You can go back and listen to old arguments. The sort of main religious liberty cases can be a fun way to engage with law and religious freedom and hear how the evolution has evolved and how justices have thought about the issues through decades.
Okay, so the answer has come to the University of Texas. Stephanie, you don't get a reply. Thanks,
Yeah,
everybody.
I like that. Nice job. You guys are hosting, you get to end with that.
Ahead,
no one at Notre Dame thinks about religion. It's fine.
Notre Dame, we don't care about religious liberty. I'm really glad you're interested in it. You should check out Liz and Steve's work. They're doing important things. And I'll just end by saying I'm so grateful to be here with you both. This has been such a fun conversation. And thank you for having me and for taking time to chat about these things. It's always fun.
And I would just say, look at places like the Religious Liberty Initiative at Notre Dame. Various other law schools across the country have similar programs, and there are lots of scholars around the country thinking about this stuff. So if you go and look at anyone's scholarship, you'll see them citing to other scholars who are working on similar issues, and you can read and get a nice variety of opinions and discussions and get a sense of the academic debate if it's something you're really interested in.
And to one last comment Andy's left about, like, aren't we just replacing one thing with another with tandem? I think that's right, Andy. I may not think it's as much of a problem as you do, but I do think it's a different animal under the tandem scenario.
Yeah, that was a great question, but I kind of felt like it was almost like we need to have everybody back for a second session to pull that off. So thanks to both of you so much. I wish we had more time. It's just been wonderful and exciting for me to hear both of you talk about these very important issues. And I hope you have a wonderful rest of your week. Thank you so much.
Great to see you.
Thank you.
Bye.